The same when you are Quababio eba Adom TV. So today in court, Jumediene yade Bremu meeting your say bonso. Yet not to say at 10 p.m. and a Jumedie eba area. Kaise a Chegu Adom 106.3 FM and Afia Sempa 94.7 FM. Sounds now called Facebook Live. Metre Adom TV and Facebook page. Ubitimi Ashe Jumedie Live. Asempa FM Facebook page and Afe Adom FM Facebook page and so ubitimi Ashe Jumedie Live. Na fa comment ni go homa yen na yenhwen kan emamo. Enti today in court and in Samakoso e Supreme Court. I think Monday no ye baba betnase, Tuesday ye san baba betnase e share mo bose ene Thursday Supreme Court e the ruling ebeba on application lawyer for the first respondent, electoral commission lawyer Justina Menuvo. Is almost closely one case after such a social case or more closely case, no mature petition the case, no. Easy lawyer also can so almost closely on the case. Now, among year or my dreams on befre or witness, Jean Mensa, ama waba witness box name. Second respondent in so lawyer for also can say Peter McMahon when you had your befre about witness box name. Chachune wa nyadwe into court ne share say Edwada no omumra emeye one addresses any day. I think on Tuesday and omoye addresses na court need to share ene say or the ruling beba. Inti ene court ni ruling aba in sembebre na PPM mu aba lawyer Tachusi Kata assign waka say ombesen astre court ni say oma won kwan na omu case a omu close ye na omu sign so MBA following the Supreme Court ruling ene. In some was ye di hon komo anwumre no edoso na said ye se ye bebie nsem na wonso wetimi atenioma se eyie and said the bia no lawyer Justice Abdullahi ewa and lawyer ochrekere ni ochremra ewo University of Professional Studies Accra on law faculty and to abe cancer wa ha obeboa yen na ansana no ma me fentwem sa aboafo eboa yen me today in court ebrem no edoso. Your petrosol say clean fuel in full quantity is always a delightful experience. And your DBS roofing, we truly are your roof expert. Your Koa mixture in Canania from Koa FS, almost say the immune booster for your general well-being. Omona Boyami today in court, Jumedi and Bremo TV so radio so and RFA online. Intia de Numekuina Ase Papa. Lawyer Justice Abdullahi Akwaba na pom to say.
Obi. And Nakopon and Mompa Bunti.
And then Samakoso.
Nedia head. I am so.
Yeah. Depending on baby no ede anase enyo ede emma. Enti ene ye won sem bebre na ka. But to start off no justices ne betna. So first no mo ye say omu deliver omu ruling on Tuesday argument our lawyers no eye. Now president of the panel on also the Chief Justice of the Republic of Ghana Anini Yeboah JSC yenkonko tie ruling or kanye on behalf of the court.
In Tai and another versus FIBA International 2017-2018 to Supreme Court Ghana Law Report 906 at 919 Poaman JSC opined as follows, quote, "It must be remembered that the fact that a defendant does not appear to contest a case does not mean that the plaintiff will be granted all that he asks for by the court. The rule in civil cases is that he who alleges must prove on the balance of probabilities, and the burden is not lightened by the absence of the defendant at the trial. The absence of the defendant will aid the plaintiff only where he introduces sufficient evidence to establish a prima facie case of entitlement to his claim." End of quote. In Ama versus Hydroform Estate Limited 2013-2014, to Supreme Court of Ghana Law Report 1551 at 1567, which was cited to us by Counsel for Respondent Benny JSC held as, quote, "A court has no duty to call upon any party to testify in the case. The court acts as an umpire and only hears such evidence as the parties will prefer. Whether the parties will testify or not is none of the court's business. Indeed, a court to insist that the party should testify will amount to the judge descending into the arena of conflict. After determining the tribal issues, the trial court leaves the field clear for the parties themselves to decide who will testify. We know of no law or rule which entitles a court to call upon a party to testify in the action. If such a law or rule does, we would venture to say that it is inapplicable under legal dispensation. End of quote. Finally, we refer to the case of the Society of Lawyers versus Sir William Otto Jeffrey, BT 2000 Queensbend Division Commercial Court, which on the facts is similar in terms of procedure with the current case before us, and cited by counsel for the second respondent. In that case, all the witnesses had served their witness statements in accordance with pre-trial directions under the civil procedure rules, but lawyers had decided not to call them to testify at the trial. An application was made to the court for an order requiring the opposing party to call the witnesses at the trial so that the applicant could cross-examine them. Creswell J. held that in civil proceedings, the trial judge had no power to dictate to a litigant what evidence he or she should retender. There was no obligation to call witnesses. It was counsel's duty to decide what evidence was called and the order in which it was called. The instant court had no jurisdiction to make the order sought. The law is therefore settled that a party will not be compelled to enter the witness box and testify in support of his or her case. It is a risk parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Laws case to the peculiar facts of this petition because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Laws case, like this petition, also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. We are mandated to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64, Clause 1, challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
And the Justice Anini Yeboah, Chief Justice of the Republic of Ghana, President of the Supreme Court panel, at 2020-2021 presidential election petition. Yes, so and I'm say or they ni ruling atuja, and this ruling is historic for so many reasons. Going forward, a precedent in our jurisprudence ewa Ghana. Intia nkomo ihia papa. Na ukai ruling na ewa ewie na meka se petition ne shasi and way any ruling na court ne deliver as a ewa pa because all this while ruling be a summarized one, short, simple, pa. But we know ewa for so many reasons because of the issues laid out and not a dorsal. Lawyer say, what kind of ruling now? Me categorizing into 3 parts. Number 1, now on the fact about chachu argument say witness ninya filing a witness statement and not just a way elected. Say obema evidence. Court ne share da spend their time from one understanding they would say, you know, na court ni decision on no yes and as I share the other part of the ruling.
Obi say yebeha I'm here Adom TV. Yebeti Supreme Court o here. Na yensu asase dia say me say the come o ha bia no. Enebem.
Yeah.
Se me kan bibia na de me kan se se ye mum kra na ya shada aya ya adwene se ye predict ni bi se be ya ye nkunyasam se nkanya sa nkoma yedi no ha nyina efa de esie ene de ebesie no se me ya ahwa na se jama ase wonyini yi kire kakra e wo niemam abra yen sheda mo ye pa bia se enya ne yi nenso o man ne ye ne esompa de so man nti no Yet minya daje ebie nsem no kirechire mu papa mu ma sabio ne nko ntiase akra no wonya ntiase abra free MPP ne NDC for ho neighbor.
That's true.
Nti men sheda moya baso pi die nenso to da bia dem se wa wan kamfo ho ana nkamfo na ya ira won kwem. Nti obi ya de nti mon prayer kakra
really you put I think it's good. It's good.
Toss be so Bekaya, well I mean just even to re-emphasize on that. Wa kra na nansane na ehia ya yedidi nkomo ya na wa ka say na supina so no suni ho ampa ni we ya
anu so aba
supina so abam say am say jama fa no nyina am say jama mu oyen ha mum ne am say jama mu tie legal advice ko dia kanyina ibe wi akire na say afa no nyina no na mu so ko fa so mu so ya no mu di atam enti obi and what the kaka so Bekaya said making 3 days ago you can answer me election no anyhow that is dealt with and the Supreme Court trinity wakra says we elect here any evidence what ka say obema obe everyone saying obe di dance here
statement
no and try say who di dance here until say you be gina da kam na wasai na wagia tum say sa witness statement na outro no waje atum say you no asem a opese won so dey bo court no e ma court no di asem no until so
evidence
until that time no ansana abe evidence
e ho de oduru a wuntimi mpoli ya
am mum na wuntimi entwen sign according to Supreme Court no sa am there so what you saying court no bitima show amodi adanse so we ni adanse na court no bitima atwa so contempt. Inti, one thing is clear, at least as at today. Say, file witness statement, any evidence for any reason. Witness statement, any evidence.
And based on that, into being to mean compare.
And now, to mean, because Cinchina, what file witness statement in no, a yes, Cinchina would you dance here was him. And ne, Sam Rari, a beamra, dahwa. A free necro until Supreme Court a china or mess some margin day. Emre da honi.
Emre da hono no.
I say yina a lawyer for a law student, judges, and you will be a with him ran or him ran or them marriage maybe a the free necro. Emra I better hono no.
Almost I can be on unse lawyer Tachuse Kata argue on two fronts. Say nipa natural witness statement apart from an on so no. Affidavit bia or the bar
sign
was
sign was out actually we say obedia dance it was said
and also court neka say any evidence before the court in the instant case air cosui
yes and affidavit no you dealing with affidavit na manatwem
okay
affidavit bia no say you file motion affidavit ka ho opponent no so file affidavit ba kon ye friend affidavit in opposition ba kon ye friend affidavit in support. Sir, court no enya deal with asem na sa affidavit no so utie ya etwam enti eno ho asem no em se utie Supreme Court na say wo de be kan asem a enye isan say affidavit eso ya dance di on its own but ya dance di in respect of the matters
na wo ho samre no
sa affidavit nim
okay.
It is a metro in a particular affidavit say media dance here. And on in say se time no so na se me se media dance here obetimi ahyem.
Obetimi ahyem.
Utie Supreme Court on dia.
The omode ba ya.
The omode aba no.
Wow. Inti enono settle that part. The other aspect and so say lawyer Tachuse Kataka say election petition case unique. Lawyer for na Moses sui generis into one of its kind. And Mami Jean Mensa so the head of a constitutional creature. It is why a constitutional ejuma in the interest of accountability so be boom contact or minor and also better box name na okasa. Court neka say there be the facts so constitutional officer and interest or no rules I was say the man no I was say yes strong ko efiri omo aka no adentia
sense obi se we dey ase nkomo yedi no benada na na e be yes bobo so bi ma ye kan na ne so ye sense su dia se no kre se ye krom ha no ye nimra se bi we chechire afa bi ene nimra chechire aban adwumayefo ene nimra se bi we chechire kai yofo ne yeah ya ke ya memeti hei ya me hwehwe ye nyi se bi o ye nimra bia for timamufo ene nimra bia for adehye mra ba ko pe ene chechire ye nyina na ebo ye nyina ho ban eno ntini Supreme Court nse mo kan say ampa election petition unique ne say sabio the Supreme Court nko eno nko ne one of the things Supreme Court ankasa etena se edi asem te say the sabio court bi edi asem
okay
so ye no free ho asem bi ani ho e Supreme Court yedi ni say nti eno ne man ye unique pa say lawyer for ko gina ho na ya fraudance for we say obehu we ya na ya district court circuit court and high court ho ne hu sa na ye hwe no Supreme Court ensi wo Supreme Court ensi wo Court of Appeal crowd bi crowd ensi crowd nti ho de kopem say da ebia temu da beba crowd hu bi ho crowd because ho de unique no crowd bi ni ho
okay
na Supreme Court de we nkwa na abehu this senya election petition so what we na on fee say obi obedi president woni nyin ho a e bi sit da enti unique in that life
oba ho me so was our uniqueness no na yakwa akohwe we aba ye ba the final part of Supreme Court ruling in so ebedi ho nkomo na afi yakọ other applications petition and so be sign e de aba enti ye nhwe we mra ye ba ye to aso. After 9 today in court Sony ewa Adom TV live also ewa Sempa 94.7 FM and Adom 106.3 FM midin your saibon so petrosol eboyen clean fuel in full quantity is always a delightful experience. DBS Roofing, we truly are your roof expert and your Okoa mixture, the immune booster for your general well-being. And you may queen a day today in court, Jumediano Abremo, lawyer Justice Abdullahi, and Ama Yedi Enkomo. We've been going through a ruling into detail. Any areas are you free say interest and what's he breaking it down, Mamunina Mutumi Etias. And the lawyer here corner the issue of elect because lawyers actually can't spend their time or pass once I file a witness statement actually what jiatum say obeba bigina box name Supreme Court ne boy no go and almost sign eba the point about say what was this point apart from the point say accountability constitutional officer accountability and also be jina na ubun kontama Ghana fo nyina ehu eno na uyi eno ano ne
eno na sabeka ya we de mensa ensha se mfi last Tuesday na make say ye wo kwan bebre so ho a abanjuma mu mpanifo e fa so bu akontan e ma o man no enti se sabio se ka kontabuo nko ade a enka nya election petition nko a ena ubenya ama electoral commissioner wabu akonta enya honko a
okay
in fact sabio even though nya no asem ne yeka no but se ma ba ko pekra enne sen ba ko example ba ko ne se me no kasa sesi e se o man ne pese electoral commissioner ebu akonta parliament ebetimi afre electoral commissioner se oba hema braya so e enya so mo kra na ekọ hompo
okay
ye frɛ no ono afri ni office
aba
wanante aba betena parliament ni ahye no se wo dwumadi akodi 7 December bu ho akonta kyerɛ yɛn Ghana fo nyina eti Ghana fo nyina ehwɛ emra hye no se nsɛm bi o mabisa de bia no obeya no sika o spend ye kwan kro fa so spend sika no enema otoye ba bi otoye efri ye kwan kro fa so toye se ne mra fa na se ne mra nko se ta adwunim na se nto adwunim se bio kwan ye fa so o hyehye abato no ekowie sen hwan ne di nkunim den na nipa ne kodi nkunim esi den na abato no obobo oba no mprensa na ne mpre nan so na mpo dumpo so
Nina parliament bit me ebusa.
Nina parliament bit me ashano. Ama or the nina ho answers aba.
Now then in the highest court of the land, yentimi nyesa ade no.
In the highest court of the land, the court bit me ashano. Ama na kan semi nyina. Na enko wie se asema akọ dru court wonom no e fa sanse nsem no ho. Nti enu nti na bia make say mefa ne say sempo ye cry ti hei. Enko ba ne say bia watchro ne letter. Se wo hia akuntabuo o man bi ye nyina de hye bia organ ha bia
right to information law ni nti.
Wo tro ne say oba hema mi hia abato ye to ye mi hia ye ho akuntabuo bibia fa ho bia no boboso ba akoma. Se wanyia no a wo tumi so be gina no so for instance na ade na court na court ahye no amana ye se wanya contempt no obetuma lusu ni seat no wasan ko da fiase enti ekwan at least ye tie kra yetima ka mu be mi no se ye kra ye nu se bi lawyer for mu gina court dem we ye kra yetima ka mu bi enti nya ne sa lawyer for mpeni for tesa o mu betima ka bebri a menu mi no kra bi a ye ni ma na ye nwene ho mpo so enti se ka kuntabuo nko ade a nkanye saa kwan wi so na mmom sa odi akuntabuo no be ye argument a man no ntini se wo se ye nhye no ma ne nka asema na enkoba se at least in the mind of the Supreme Court no enkoba se won so nam kwan pa so na eba
okay
na sa tra se menhye nipa no ma ne media dance abra wono so woni dance de eno de mini hu to me esan se o wo sa to me no so obetimi aka so media dance ana woni dance
and I think to help explanations is here no court ne kan wa ha say counsel for the petitioner has strongly submitted to us that we should not apply the Society of Lloyd's case to the peculiar facts of this petition because the first respondent being a constitutional body with defined responsibilities must be brought before the court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Lloyd's case is, like this petition, also deals with witnesses who had served witness statements and have decided not to give evidence to be cross-examined. We are minded to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64(1), challenging the validity of the election of a president. And I'll say, simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondents to enter the witness box to be cross-examined. Not just on the facts of a constitutional body, you know. Court ni through Article 64(1). So we be election petitioner and ya what be accountability.
Ni tia wa no twa no. Supreme Court ne say omo dem na ye adwuma. Omo tumi no eye tumi a emra na ahyehya to ho. Na sesia se omu tie ne lawyer for no a omode asem na ba court no e kana na se ase omo na Supreme Court na no ase ompeso omu kire mu se omo entre o mahiem enkodu ba bi omu nuruye Supreme Court be so kire se sa na omu betima esa no na che se e bia emra ma ho kwan sa so mutimi entre o mahiem na bibia se ni wo pa de a omu de omu nyin ni se omu otumi so metre o mahiem akodu ba bi omunuye nti nyaade ese ombeji atum
ombeji saade na
omunyintum etoso bi em kra no apart from so omunyintum no kra no lawyer for no kra no entimi enhyeda enkansem bi a eso makoma nti no nti na eso mutimi gina so kase e bia nsema waka na so aso ye nipa nti gina so ne de atre yashim nti first ono so wonyintum second was atre say wo kra no kra ntimi convincing no
why was or trainer shame just accountability argument na etum
enye yesa because baby won yes away
yeah the other bit about the ruling here on say the law is established say untimi enforce obi mane mema witness
that's na ya ka ntimi ntia say of course you made the you made the my then say asem kro na no wo the lawyer for do ejina ho a
be adwin different
be adwin different and then make we e man ye de na sama ne so e san say senke nyina ya na okodom kra nka e bia nka ne nka law kra nka anya kra na nka ye isan say emran de okaso ubisa lawyer for do say emran ne sen a omu nyina be ka asem kro na obia nsasa na emom ma asem nsi na ka se na asem a asie yi emran ne ka ho sen ho na echinyene be sha ase
echinyene be start
utra nyeye na se wo de osu di skakra to so na yenko ka asem ya wan hwe a sabio se okra na wudi asa na okra be confused because the lawyer bia be ka bia no eso ani na to aso mu so isan say adwuma lawyer for ye no no se ombetima ka asem de ay to aso mu na enemra no so ekọ ama wa wote hwa na otrim kra ebu afo se na me kra na man hua ni ya na se lawyer ni nim asem ka sem sa na adwuma no okwa
esi ekọ
sa na ekọ no itreni wo kasa nim ni itreni wo mranim nti ansa na be pie no anye bia e fam na ho de wetimia ada adane kasa no ama ba bia wo position ni wo no ene ne be fa but as to say judge no wodi asem no ono be ya adwena na so no nya adwena na ho no na
different
enu nti na da bia ba akofo na tie dwam no no na e kire se yenko ne sia na se yenko ne sa nti Supreme Court ne judgment ruling mu dia ba no dia nyame anim ni said ye sha se di kan kan no enya fa bi de fa bi susu sa mu bosi nemum me kai say a very dangerous decision Supreme Court agitum sampa a very dangerous decision and respondents na taking because the risk involved no e mo do ye pa eso but say them sa kan na no in the danger no a horse now here the confidence of the respondent also lies.
And also if that electoral commission and another danko akofado me ba me ya share the other directives court no emma going forward and sana ya share lawyer Tatushi Katan so indication or ma to the court say on be filing new application. In fact here ka say sa applications no ma file number 1 a application to reopen case ni bio na omatimi atonsa afre witnesses and o ma indicate wom say on be frɛ Jean Mensa as omo witness lawyer be kire ye mo say ye koba sounds no ma file application for review of any ruling Supreme Court at the ebai but mamen ka say petrosol eboayen na nsan mremu ayeden kakra and wonim say is ye nyina ya ba be the boni friend value hunters but are we hunting for value the right way? Kai say wo engine da wo car mu no more valuable than just cheap fuel. Inti mo a monto fuel papa e wo bibia be ma fuel papa no but more than a channel so be smart and hunt for holistic value. So wo pay holistic value pa dia say wo quality fuel go car mu at the right quantity. Say fuel no ko bu a yembu ensisiu na ebo e wo se wo tua nso e na wo betua for fuel. Baby, I benya saadi ni nyina ye petrol so na okwa petrol cell on be ma clean fuel hote in full quantity ne bo nso eye nti sa value no ubetimi enya nti bomodin na on petrol so in the enkomo clean fuel in full quantity na ye ton ewo petrol so and yen konkoshe we emra ye ba ye be sign the Marco Supreme Court. Today in court, Sune Adom TV, Asempa 94.7 FM and Adom 106.3 FM. Ma yenhwe as we wrap up and indication and say yemra akanisa nti o say yehwe na court no directives o ma going forward and it's parties ni nyina submit your more saying written submissions by the 17th of this month. That is next week Wednesday. Na Thursday 18th no momra court na omoma oral argument be no momma highlights of the submission That is what I expect after any ruling in Meboa.
Not entirely.
Okay.
I think this was a decisive decision by court. No, it's answer. In my expectation, no, me fee say anka ruling no, nke a beer, nka ombetu ashada ebia emra ochina na say joada na brada. For the parties, maybe to either address the courts or BB. I mean, not anything substantive because really, after Neno, truthfully, there's no business.
BB any hobby.
Nipa nenya asem no so ni feka. Nti no na wi asem neka.
We are closing the case.
We are closing the case. We be odi me maybe me there. But na me fee say bia nko me from afa so kakra.
Okay.
Na bia nka Joada na asem na nke ba. Nanka a few mobima orders
directives
for addresses to be filed and then for judgment. Usually ana oral reference saying addressing to Klananka.
Okay.
Nka omo file wi a CBS chase be filing by 17th. No 17th no be file 3 weeks time no. That's 21 days and nanko mobima judgment number. So this is in a way this is what I was hoping to happen, but of course, petition also indicate so we file motions. In fact, here we time we file motion na. Em so mo kokos no prepare. Motion in your motion na. Yeah. Pon court answer na ye prepare. Motion na ye city na dey. Ye prepare answer na ye court.
Yes.
And the time na the file motion, you know. It was too good to be say there. And it looks like Omar also maybe it's a consistency with which Supreme Court refused to petitioners and applications and no just preparation towards any eventualities. So Nina could be a reason a manti omo etimi omo here hasa. But it shows indeed almost omo bo omo ho say ombeko. Yedi kan no show you say Jean Mahama lawyers no omunyo madwene say semra kitikitikitikiti crowd na so metiki advantage a omunyo man so masa amra na dwom
omoma ni ntwam
sida emra bia wo nwoma no bia no o metiki advantage enti say yesi asem ye bewie ne pa na bia ye ya dada ho because kitikiti bia omra no bia no they would exploit. And right from the day, and this was because right from election registration time no, and no feel almost Mahama camp no feel almost say, and now there's some big jam BBA chum keke. BBA no, they will make sure they explore the laws to the limit. Okay. And consistently, and for me, I am proud of them because Omashu a level of consistent lifestyle, and Omashu said, Omamap emra. Ayejuma. It is a Nipano Enya a tune who's obesa. I think say a boom basum. Rather than say you canena nan kumunam, Juma no more say near man and no dear. Ye for more mine. Matter. Ye demra and a boo of mine.
Matter. Lawyer, ain't the awareness, Yabedas, na Yashe Asaya.